Hi, welcome. My name is Tessa Dysart. I'm the Assistant Director of Legal Writing at the University of Arizona James E. Rogers College of Law. And this is our LWI recorded presentation on bringing lawyering skills into the doctrinal classroom. So I'll serve as your moderator. I'm going to introduce the topic briefly, introduce our panelists, and then give my little spiel, and then we'll move into the recorded videos from our other presenters. I'm going to move my little video because it gets in the way. So hopefully this works seamlessly. We all know the progression of legal education. So we went from a system full of practical application, reading the law, to a mixed system, to a full-on case method system at the end of the 19th century. And while the case method certainly had its strengths, it also had weaknesses, as pointed out by noted philosopher and later judge Jerome Frank. And Frank was right to criticize legal education. It was a lot of seeing, but not a lot of doing. But unfortunately, despite his criticisms, the system, the mode of legal education, remained largely stagnant for over 100 years, dominated by the case method and the Socratic method. The ABA in the 1990s started looking at ways that it could change. And the 1992 McCrate report that was put out by a committee of the ABA recognized there was a need for more skills education. So in surveying newly licensed attorneys and employers on what skills and values attorneys needed before assuming professional responsibility for a matter, the task force found that written and oral communication were some of the most important skills for attorneys to have. But as evidenced by this chart here, the newly licensed attorneys thought that law schools were doing a poor job in teaching these skills. And this really isn't a surprise. The ABA did not add its first writing requirement until 1981, and it wasn't until 2001 that the second writing requirement was added, so a writing requirement outside of the first year experience. And it's interesting, you can see just the change here in the terminology. In 1981, it was shall offer, and then by 2001, it was shall receive. So not just did the school have to offer it, but the students had to receive it. I was one of the first groups of students. I graduated law school in 2005, and I was one of the first groups of students to be subject to this second writing requirement. But I would say that my experience in law school is similar to that of the After the JD report, which surveyed newly licensed attorneys who entered practice in 2000. That I didn't think that the practical education was very well done at my law school, and that there was certainly a need for better practical education. It really wasn't until 2000 with the Carnegie Report that law schools started to incorporate more lawyering skills. So the 2007 Carnegie Report, Educating Lawyers, did find a need or a desire to have integrated curriculum that included doctrine, analysis, lawyering skills, and professional identity. But I actually think it wasn't just this Carnegie Report that prompted changes in law schools. It was the downturn in the economy and this need to become more competitive and more interesting for students. So what are these skills that our students need? And I know I'm a little bit preaching to the choir here, but one set of skills we see are the Schultz and Zedeck effectiveness factors. There's 26 factors that students need to find, more than just doctrinal knowledge. And then I always like to share with my students this National Conference of Bar Examiners study that studied newly licensed attorneys on the skills, the doctrinal areas, the abilities that they needed to have to be successful in law. And 100% of newly licensed attorneys said they performed written communication, and things like paying attention to details, listening, professionalism, critical reading and comprehension. These were all skills that our students needed. The highest doctrinal skill actually was civil procedure. But unfortunately, practicing attorneys still think that law school isn't doing a great job. So this is a 2014 survey done by Barbary, and it revealed that only 23% of practicing attorneys believe that recent law school graduates possess sufficient practice skills. So how do we teach better practice skills, better lawyering skills to our students? And that's what this panel is all about. You're going to hear from Adam, from Jane, from Aliza, and from Jennifer, and from myself on different ways that we incorporate doctrinal skills or lawyering skills into the doctrinal classroom. I'm going to start with a brief discussion of my constitutional law class, then we'll move to Adam. We'll talk about transactional drafting. Jane will talk about using visual images. Aliza will talk about reading, and Jennifer will talk about creating authentic anchors. And so I'm excited for this presentation. I hope you find something that will help you in your law teaching. So let me start with my discussion of an integrated approach to constitutional law. And I always reach this conundrum when I'm teaching constitutional law. I've got a case book that's a couple years old, and I've got a US Supreme Court that's issuing decisions that's going to greatly impact how my students understand these doctrinal issues. And so how do I address it? I decided to create a formative assessment that took a group of cases, a group of Supreme Court cases and pending cert petitions. I used the ever popular SCOTUS blog to find my cases. And I would divide these cases into 3 or 4 groups. We'll just say 3 for purposes of my discussion here. It varied the different times I did the assignment. And those 3 groups would be by topic. Maybe we're studying equal protection or the First Amendment speech or First Amendment religion or, structural provisions. So I would assign them by topic, and I would also have time in mind. So I usually like to assign the cases after oral argument had been heard. The students would then sign up for a case during a particular time period, and when their time period was due, they would write a blog post on the case. They would talk about the issues in the case, the arguments of the parties. They would give you a summary of oral argument, and they would anticipate how they thought the Supreme Court would decide the case. Other students, so students who are not writing a blog post during that time period, so theirs was at a different time period, would then comment on a certain number of posts, creating a class dialogue about these pending Supreme Court issues. I found the assignment to be incredibly helpful for the students. It had lots of benefits. So it engaged my students with different type of documents. Instead of reading highly edited cases in a case book, they were reading oral argument transcripts, briefs, unedited versions of cases, blog posts. They often would refer to SCOTUS blog for their own understanding of the case. They had to write, back to this 100% of lawyers write. So they were writing and trying to express complicated ideas in a way that their classmates could understand. It kept them current on the Supreme Court's terms. So they, more than once I had students reach out to me in June and say, oh, Professor Dysart, when all the cases came out, like I understood what was going on, especially those hot button cases that come out in June or July, like in this year. So it kept them excited and interested and current on the court's term. And then it taught them to work independently. So each student was working on his or her own case. And so they were, might be commonalities between cases. You would have cases that are dealing with similar doctrinal issues, but they had to go find the case and do the research on their own to write their different assignments. The challenges, of course, as always, is grading. Having students write blog posts that might go into 1,500, 2,000 words was a lot of grading for me, and then grading the individual comments and making sure everyone did what was required by the assignment. It was hard sometimes to find a number of cases, so I typically did this in smaller classes of 20 to 30 students. I tried this in my 1L con law class, a version of it, this past spring, and I had like 60 students in that class. So I ended up using a list of about 20 cases. Actually modified it a little bit. It wasn't as much a Supreme Court assignment for my students, but it was a similar style of structure of writing assignments. So I had a list of about 20 cases, and I just divided my class into 3 groups. So each group wrote on the same cases. So I had 3 students writing on the same case. But you could easily do this with the con law assignment too. And then I had to manage expectations. This was a lot of work for students to find the cases, or to find the materials, to read the briefs. I had students with the Supreme Court assignment go on and read, amicus briefs, what they certainly weren't required to do, but they got so into it that they did. And I would have students tell me, we spent a lot of time on this assignment. And so, helping the students understand why this was important, teaching them, new doctrinal issues, engaging in different materials, writing, why this was important, and then making it sort of worth their while by, in the end, making it a significant portion of their grade. I think by the last time I did this, it was worth like 20% of their grade. But overall, I was pleased with the skills my students learned. Research skills, writing skills, reasoning skills, engaging in respectful discussions about really controversial issues. Overall, I think the benefits outweighed the concerns. For my students, when I taught on the East Coast, I actually culminated the assignment by taking my students to the US Supreme Court to hear arguments in a case, and that was a lot of fun for them. It's a little harder to do from Arizona, but I hope you enjoyed my discussion. I'm happy to talk to any of you. Feel free to email me if you have questions about this assignment. We'll move now to Adam.
Hello, my name is Professor Adam Eckart, and I am an assistant professor of legal writing at Suffolk University Law School in Boston. I'm going to spend a few minutes discussing how success in teaching transactional drafting in the legal research and writing course can inform other first-year courses, including doctrinal courses. Many law students go on to practice in transactional settings after law school. By estimates, approximately 50%. Yet much of the law school experience, especially in the first year, is litigation-focused. Even for those students that do not go on to practice litigation, some basic foundation in transactional drafting could be helpful, since even litigators may serve corporate clients where they need to understand contracts or agreements. Further evidencing a need, both the marketplace and in law schools, the 2017-2018 Allwood survey indicated that transactional drafting or contract drafting courses are the most popular upper-level legal writing courses, having a longer wait list than any other advanced legal writing course. While some legal research and writing courses teach important aspects of transactional drafting, there are also opportunities for doctrinal courses to introduce elements of transactional drafting in many of the same ways that legal research and writing courses do as well. Although there are many ways to introduce transactional drafting skills into the doctrinal classroom, doctrinal professors can introduce transactional drafting skills in 4 simple ways, including through building upon legal research and case briefing, asking students to recall and apply briefed case law in revising a preventative writing document or a portion thereof, such as a sample agreement, a lease, a contract, a letter of intent, or other documents to be compliant with the briefed case law. Students could report on parties to a case, at drafting recitals of a future contract based on identifying information about a client or a counterparty in an assigned case. Students could apply precedent and course concepts to transactional drafting. Professors could ask students to review draft documentation or contractual provisions for 2 hypothetical parties and opine on the legality of the provision based on the precedent and course concepts after they've been discussed in class. And the 4th is professors could build upon key course concepts by asking students to draft model provisions or definitions of a term of a contract after a review session or prior to an examination. There are many different examples of how doctrinal professors could integrate transactional drafting skills into their course. I offered 3 here for context, but each professor could think of a variety of agreements and documents to use to tie together substantive content with an opportunity to draft transactional documents. For example, in a contracts course, after teaching students about consideration, a professor could give students a couple of samples, 1-page agreements or provisions of agreements and ask which ones contain consideration. And for those that don't, students could revise the provision to include consideration. In a property class, after teaching students about the different types of easements, a professor could give students sample easements and ask students to classify them by type. Additionally, a professor could then give students a hypothetical and ask them to create their own easement of a particular type. Finally, in torts, after teaching students about assumption of risk, a professor could give students policies from a ski resort or a baseball stadium and asked them to devise a model assumption of risk policy for their university's basketball venue or other sporting venue. For additional examples of how doctrinal professors could introduce transactional drafting into their courses, or how legal writing professors could introduce transactional drafting into their courses, please see my work on SSRN or feel free to reach out to me directly. Thank you for your time.
Hi, my name is Jane Grisé. I am the Director of Academic Enhancement at the University of Kentucky, J. David Rosenberg College of Law, and I'm also an Associate Professor of Law. I am pleased to be part of this panel that is discussing teaching methods that have worked for us as we teach lawyering skills. These methods can be used in a variety of classrooms. I teach legal writing. Before anyone can write, they need to understand the cases that they are writing about. I have found that student comprehension of cases and statutes improves when students are asked to explain cases using visual images. I developed this technique when I was part of a faculty fellows program a few years ago, and we took classes on using written, visual, and oral modalities in the classroom. The idea behind the program was that students learn better when all of these modalities are incorporated into the classroom learning experience. We were required to develop a project, so I decided to try to incorporate visual modalities into my legal writing class. This was challenging because most legal writing classrooms involve writing and oral advocacy, but not the use of visual images. I did some research and I found that the phrase, "a picture is worth a 1,000 words," was written by an advertising executive in the 1920s who promoted the use of images and ads that appeared on the sides of streetcars. This concept is applicable to education as well as marketing. It turns out that we all learn more deeply from words and pictures than from words alone. This is why many of us use PowerPoint slides with images and words. When we look at words and images, our verbal and visual processing systems are engaged, and these two systems complement each other. When both systems are used, we gain a deeper understanding of a concept. It also appears that the process of translating words into pictures requires deep thought. You often have to go back and forth between the text and the pictures to check your comprehension. And if we are asked to pick an image to illustrate a concept, we typically pick an image that is related to our interests. And this helps us connect a new concept to our own knowledge. Research has also found that if we are asked to explain an image to others, our comprehension improves even more. Given this theory, I thought that law students could benefit from using their visual processing system as well as their verbal processing system to better understand cases. This would help them understand the cases more deeply and give them the opportunity to practice using visual images, a tool they might need to illustrate concepts for courts or clients. So I developed an assignment for the spring semester of my legal writing course. The class had been assigned to write an appellate brief. I took the key case for the brief and divided it into 19 sections, the number of students I had in the class. Students had to read the entire decision and then find an image that represented the main ideas in their section of the case. They sent me a PowerPoint slide, and then they explained to the class in 2 minutes or less why they chose the image and how it related to their topic. I've done this for several years, and students seem to understand concepts faster and more deeply. And I'm going to show you some examples of the slides that were created by my students. The topic of the appellate brief was defamation. So one issue dealt with whether a teacher was a public figure who was involved in a dispute. And one of my students found this image to illustrate that part of the case. Another student created a slide that dealt with whether this teacher had access to the media. And this image related to her interests. Two students explored the meaning of actual malice. And this is the first image that was found by one student, and this cartoon was the second image that was found by another student. Now, this technique can be used in many settings. Students could be asked to look at a sentence in an opinion or from a statute and pick an image that illustrates the concept. And this can be done in large classes or smaller ones. The slide that you're looking at now was done by a student in a bar prep class. He illustrated the crime of robbery by having his dog pose for the explanation. And this resonated with him. I recommend that students, that teachers use this technique because it works. Students understand concepts more quickly and thoroughly. It's simple, it's fun. And finally, in this day and age, our students need to be able to communicate in many ways. Lawyers write, they speak, and they also need to know how to present visual images to clients and courts. So my recommendation is have some fun and add visual images to your assignments for your students. Thank you.
Choreography is design. It is a deliberate sequencing of steps. In this chapter for lawyering skills in the doctrinal classroom, I suggest that we approach reading as choreography, and specifically that we consider 3 steps for teaching reading. Reading, of course, is fundamental to lawyering, but I think that I held assumptions about my students' reading habits for a long time. For example, I assumed that they liked to read, and I assumed because they had made it to law school that they had a way to manage a regular reading load and even a heavy reading load. But experience has taught me otherwise. I teach both civil procedure and legal writing. Much of what I have learned about my students' reading habits, though, I gained from legal writing classes because that's where we observe them closely. It's clear to me now that law professors across lectern, doctrinal, clinical, experiential, should be talking about skillful reading. We should lift reading instruction from a hazy aspiration to honest instruction. Let's approach reading then as a 3-step process. First, acquiring knowledge. Second, synthesis and finding patterns. And third, evaluation and response. The first step, acquiring knowledge, is reading comprehension. We want students to grasp the main idea. In civil procedure, in the first few weeks of the semester, reading comprehension is all I really expect. Note, though, that reading comprehension is not as simple as it seems. Some of our students will have the tendency of reading a little and then forming an opinion quickly. But research suggests that, quote, comprehension can decline when readers place too heavy a reliance on their prior knowledge and ignore the text. So I created a recording for students that shows me reading a moderately complicated case. It's posted for the students in the first weeks of the semester. And during the recording, I give students my thoughts aloud as I'm reading the case. I am modeling for them how to check for comprehension. Naturally, the message is that highlighting is not enough, rereading is not enough, and nor is reading someone else's summary of the case. We all expect more from our students, though, than just acquiring knowledge. The second step in the choreography of teaching reading is synthesis and finding patterns. In this step, we weave together subrules. We also want students to find patterns across cases or topics. In civil procedure, for example, I want students to read for patterns of due process, efficiency, and federalism. To build the skill of synthesis, keep referring students to a table of contents or focus their attention on closely comparing the language in two different sources, maybe two different cases. Legal writing professors know something else about synthesis. The real test is writing. Students who understand what they read will be able to connect and find patterns and organize the material. That's a natural test in a legal writing class. It should become part of teaching in doctrinal classes too. For example, students could be asked to write a rules paragraph after they read several cases in a particular topic. The third step is reading for evaluation and response. At last, the higher level reading that makes lawyering challenging and also rewarding. This is the step of talking back to text. But here too, let's be explicit in what we mean by evaluating, what we are looking for. I might clarify, for example, that when I read judicial opinions, I am trained now to identify the evidence upon which the court relied. Or it may be identifying the court's assumptions, inferences, or the historical context in which the decision was written. One technique for developing evaluative reading is to ask students before they read a case to imagine representing one of the parties. Now they will read the case with a purpose, to find support in the decision or to distinguish the facts, just as a practitioner does. So by casting them in the role of an advocate before they read, their reading will improve. I've known this from teaching legal writing because some of my students always perform better on the writing assignments that ask them to represent a client, a fake client, in a court, a fake court. The charge of advocacy leads them to read and write with creative purpose, even when the situation is fake. Overall, this chapter of reading choreography summarizes the legal writing scholarship on skillful reading, of which there's a sizable amount. And new scholarship on reading continues to develop. We are not alone in facing this problem. What Carolyn Williams from the University of Arizona recently called a, quote, wicked problem. Reading well takes practice, which many of our students may be lacking. I do end the chapter, though, with a nod to health and what is needed to read skillfully. Sleep, nutrition, and exercise matter. Calmness and concentration matters too. It helps me to remember that reading is a habit. It can be formed later in life. Students who don't have a solid reading habit when they appear on day one can learn to have that habit if we talk to them explicitly about skillful reading. Some days I am discouraged by my students' reading skills. On the better days, I remember that teaching is successful as long as I take them one step further from where they began. Thank you.
Hello. Thank you for watching our presentation. My name is Jennifer Spreng, and I teach at St. Mary's University in San Antonio. Imagine with me. Suppose the class began the day the case walked in the door. Students would use legal principles, skills, and processes similar to those in traditional courses to solve the client's problems, but in a much more pedagogically productive context than a casebook can provide. That context is the universe of the client's circumstances and legal travails, a meaningful, factually rich, highly realistic landscape that situates numerous opportunities for students to encounter concepts, hone skills, and solve problems. Such a landscape or scenario is an authentic anchor for substantial instruction. Students bring a highly motivating purpose to an anchored course, the urgency of solving the client's problems. And therefore, they invest the necessary time, effort, and deep learning behaviors to do so. Students also experience the disciplinary immersion of an expert in the anchoring story. So they learn like experts. They notice more, make better conceptual connections, and produce more integrated knowledge. By doing so, students build the more highly structured knowledge and hone the higher order thinking and reasoning capacities to do so. Students also learn when, how, and why to use their knowledge, and are more likely to retain, retrieve, and transfer that knowledge to other settings in the future, especially to practice. Legal writing professors observe these dynamics, which are well documented in education literature, when they assign high-quality simulated court records to students writing appellate brief assignments. Such problems are instructional anchors also, that animate an entire course. In the most authentic of these anchoring problems, students become attached to the litigants and deeply conversant in the law and facts. Professors achieve key learning objectives through these problems and the students' expertise, and sometimes the opportunities the problems shape allow for the course objectives to develop productively as well. Anchored instruction can animate and order doctrinal courses. Consider Clark versus Jones, a real-life litigation anchor for a first-year Civil Procedure 2 course that I have used productively on several occasions. It comes complete with actual pleadings, depositions, state and federal court motions, local demographic information, and happily for us, access to attorneys who represented the parties. Here's the story. David Jones won the election for county judge executive in sleepy, rural Ohio County, Kentucky. He decided to make staff changes and replace the county finance officer and assistant finance officer, Teresa Clark and Carolyn Johnson, with other women that he'd known for years. Prior to leaving office, the outgoing county judge executive paid Clark and Johnson back vacation and sick pay, despite legal disagreements over whether they were entitled to those funds. Clark and Johnson sued Jones and Ohio County for violation of their First Amendment rights in federal court. Ohio County sues Clark and Johnson in state court to recover the vacation and sick pay payments. Clark and Johnson then counterclaim in state court, alleging retaliation for pursuing the First Amendment case, and they joined the county treasurer, who signed the vacation and sick pay check. Discovery is contentious in federal court, and when the First Amendment case settles on the eve of ruling on a motion for summary judgment, Clark and Johnson moved to dismiss the state court vacation and sick pay recovery claim on the basis that it was a compulsory counterclaim in the federal case and now barred by claim preclusion. In this brief story are issues and materials that support discussion hypotheticals, brief writing assignments, classroom illustrations, and written and other longer writing assignments, all related to pleadings, discovery objections, summary judgment, supplemental jurisdiction, joinder of parties and claims, and res judicata. With the appropriate legal authorities, and even a teleconference with Clark and Johnson's attorney later, Clark versus Jones is a Civil Procedure 2 curriculum that students remember long after the final exam ends. Clark versus Jones is an ideal doctrinal course anchor. It's dramatic, especially for the town involved. It's also real-life litigation that ended without a definitive result, that generates surprising and really very gratifying student enthusiasm. It also has key attributes of great anchors from a pedagogical perspective otherwise. It's realistic. It is information-rich with authentic artifacts such as litigation documents and evidence. It's comprehensible to students. It animates numerous course objectives productively and efficiently, and it motivates students to learn more. But great anchors aren't necessarily real-life litigation. Professors can also anchorize their existing course hypotheticals, activities, and materials by tying them together into one coherent story, or harness litigation files, scholarship, or the numerous pre-prepared course anchors available off the shelf from many publishers. I hope these materials and this presentation help you develop and deliver anchored instruction to your students and reap all of the benefits of in terms of student learning and the quality of the experience in your courses. Thank you.